Morning for those of you who've joined. This is Kristen O'Neill. We're going to be starting at 10 o'clock to discuss the Freedom of Information Law. Thank you for joining me today. We'll get going right at 10 o'clock. Thank you for joining me today. Welcome, everyone. My name is Kristen O'Neill. I'm the Deputy Director and Counsel for the New York State Committee on Open Government. We are housed within the Department of State. They provide us administrative support. So we are a government agency. Today, this morning, we'll be talking about the New York State Freedom of Information Law. We'll be providing an overview for those of you that are not familiar with the Freedom of Information Law, and for those of you that are familiar, it's a refresher and update. There hasn't been a lot of activity in the world of Freedom of Information Law in the past couple of years, but it's always good to get a refresher on requirements, rights, responsibilities, etc., regarding the statute. Up on the screen right now is my contact information. But before we go too far, I'm actually going to stop sharing this particular PowerPoint, and I'm going to go over to my our website. So right now you're seeing my contact information. The web exit assistant keeps popping up on the screen, and it's probably blocking parts of the PowerPoint, which is a little bit annoying. But anyway, so this is our office contact information. And those of you that are familiar with us know that we're a small office. We're actually quite larger than we were a couple of years ago. We're with a staff of 5. We have our executive director, Shoshana Boulay, myself. We have our senior attorney, Kristen Smith. We have our Excelsior fellow, Miguel Batista, and our wonderful office manager, administrative assistant, Candace Watson. So if you call or email our office, you're going to get one of 5 people. But a couple of years ago, you might have only gotten 1 of 2 or 3 people tops. So I'm going to stop. I just want to stop sharing this screen right now. Hold on just a moment. Let's see, share web browser. And I'm going to go to the Committee on Open Government. Just want to take a moment and kind of play around with our website a little bit and give you an idea of the types of information that's available on our website. Whenever anything changes in the world of open government, we try to make that information sort of front and center on our website. So for example, when the New York State budget passed recently, part of the budget process, part of the passage of the New York State budget included a 2-year extender of the provision of the open meetings law that allowed for extraordinary circumstances video conferencing, that allowed members of a public body to video conference into a meeting from a private location, but only under extraordinary circumstances due to disability, illness, caregiving responsibilities. That was set to expire July 1st, 2024. The legislature and the governor signed it, agreed to an extension of that. So now it's in effect until July 1st, 2026. So you can see we put like a little notice right up on our large banner there. One person is saying they're not hearing anything. If other people can hear me, all right. So I'm just gonna put a note in the comments here that that's a 1-person problem. Hold on. Sorry. Just gonna take a moment and saying, thank you for letting me know that it's just a 1-person problem. Apologies for that. Again, and so updates to the statutes. We try to get that right up on there. When I was offering the virtual training sessions, I put that up on our website. We've had this information about the guidance regarding the video conferencing up on our website for a couple of years now, actually. Our main menu items are right up at the top of the screen. If you hover over here, we've got these drop-down menus where it brings you to the copy of the statute, our regulations, our advisory opinions. So that's for FOIL, open meetings law. Here, if you're looking for when our meetings are, that's here. We have, anytime we publish advisory opinions that we think are going to be address something new in a unique, we publish those here. Here you can find out information about who serves on the Committee on Open Government, about our executive director. Here is our contact us page with our phone number, our email address, our mailing address if you want to send us a note. Again, I'm going to go back to our home page. If you scroll down a little bit, there's this section of the page that says, I would like to. And then here, there's some sample language. So here's sample language for how to make a FOIL request, sample language for how to appeal a denial. Here's an overview document, a guidance document for the time limits for when how long an agency has to respond to a FOIL request. If you'd like to make a request an advisory opinion, these are sort of the overview, a guideline for how to request an advisory opinion. If you're looking for advisory opinions that are not available online, older ones, pre-mid-1990s, how do you get those? If you're an agency or an organization that would like to request Freedom of Information Law or Open Meetings Law training, how do you do that? Here's a button for that. If you would like to review a meeting of the Committee on Open Government that you missed, how do you do that? These programs, these training, these information sessions that I'm doing today, I record them and I post them online to our YouTube page, and you can go online and view those at a later date if you think that might be helpful, or if you know one of your colleagues is missing this today and you think it might prove useful down the road. I post them online, but in addition, the materials that I use are available in PDF form here on this page as well. So that's just, don't want to waste too much of your time on that, but I just thought you might find that useful. So I'm just going to go back to sharing the PowerPoint that we were looking at. All right. Go back to, get rid of that page, shrink that up. All righty. So in 1974, New York State enacted the original Freedom of Information Law, not the original New York State Freedom of Information Law, I should say. But it was very different from the one that we have in effect now. The original 1974 version basically had a list of the 9 categories of records that the public had a right to access. And if you didn't find it on that list, you were out of luck. That was repealed and replaced with the current version in 1978, and that has been in effect ever since, and it's based on a presumption of access. So what that means is when an agency receives a FOIL request, every agency should start with the assumption that all government records are subject to FOIL disclosure. And then they can review those records to determine whether the record or any portion of the record fits into one of the permissible grounds for denial. Who is covered by FOIL? Who can a person make a FOIL request, or to what entity can a person make a FOIL request? FOIL governs access to agency records. That's the term used in the statute, agency. The term agency is defined as any state or municipal department, board, bureau, division, commission, committee, public authority, public corporation, council, office, or other governmental entity performing a governmental or proprietary function for the state or any one or more municipalities thereof. So, obviously that's a lot of legalese for meaning state government, county governments, cities, towns, villages, but it also means school districts, libraries, water districts, sewer districts, sometimes some smaller levels of government that you don't think of. So entities that perform a governmental function. Who's not covered by FOIL? The courts. The judiciary system is not covered by FOIL. The state legislature is covered by FOIL, but they are not considered agencies. There's a small section in the New York State Freedom of Information Law that governs access to state legislative records, but it's similar to that original 1974 version of the statute, where it's here's a list of the categories of records that you can obtain from the state legislature. And if it's not on this list, you're out of luck. So FOIL, yes, governs access to state legislative records, but no, they are not an agency subject to FOIL. The Freedom of Information Law requires that every agency appoint either one or more individuals to serve as a records access officer. They must designate the person by either by name or by specific job title. They must include within that designation a business address and email address. And this person or persons has the duty of coordinating the agency's response to a public request for access to records. So when someone wants to make a Freedom of Information Law request, they must submit the request to the agency's records access officer. They can't just submit it to any public employee. They have to submit it to the agency's records access officer. Records. So what does FOIL govern access to? FOIL governs access to records. And the term record under FOIL is defined incredibly broadly. It means any information kept, held, filed, produced, or reproduced by, with, or for an agency in any physical form whatsoever. And then there's a non-exhaustive list of examples. If you don't see it on this list, it doesn't mean it's not a record. This list was created in 1978. But it's incredibly broad. Any information in any physical form whatsoever. It's incredibly broad. Under the Freedom of Information Law, a government agency is not required to create records in order to respond to a FOIL request. FOIL does not obligate an agency to answer questions or to manually create a new record in order to provide information. So the Freedom of Information Law is somewhat of a misnomer. So for example, if someone goes to an agency and says, I want you to explain to me why you did this, or I have a question for you, and under FOIL, you're obligated to answer this question, and that's just not true. FOIL governs access to existing records, records that exist at the time that the request is made. Making a copy of an existing record does not constitute creating a new record. Now, this might seem like common sense, but sometimes I've had, government agencies have sometimes questioned this concept. I've had government agencies once in a while tell me that they think scanning a piece of paper is creating a new record, when in fact, really, no, that's just making a copy of an existing record. An agency is required to provide records on the medium requested by a person if the agency can reasonably make such copy or have the copy made by engaging in outside professional service. So again, going back to the concept of scanning, if the records are maintained by the agency in paper form, for example, but the person who's making the request would like the agency to scan those records and to email them, and the agency has the ability to scan those records with reasonable effort and email those records with reasonable effort, it would be obligated to do so. Another example here is if the person who is making the request would like those records be provided in their original format, such as an Excel document or a Word document, and the agency has the ability to provide them in that original format, the agency would be obligated to do that. When an agency has the ability to retrieve or extract a record or data maintained in a computer storage system with reasonable effort, it shall be required to do so. The law states that any programming necessary to retrieve a record maintained in a computer storage system and to transfer that record to the medium requested by a person or to allow the transferred record to be read or printed shall not be deemed to be the preparation or the creation of a new record. That is language from the statute. As with any good rule, there are 3 exceptions to the rule that an agency is not required to create a record. Under the Freedom of Information Law, there are 3 types of records that every agency is required by law to create and maintain. The first, every agency is required to create and maintain a record of how each member of a public body votes on any matter. Like for example, if an agency maintains a public body within its confines, like for example, if you're a town and you have a town board, every time that town board votes, you must maintain a record of how each member of that town board voted. So for example, the meeting minutes under the Open Meetings Law may just state that you have to have a record of the results of the vote. For example, the Open Meetings Law just says that you have to say that the minutes have to say that the motion passed. Under the Freedom of Information Law, there has to be a record of how each member of the public body voted. The second type of record that is required to be created and maintained and made available is a list of the name, public office address, not home address, but public office address, title, and salary of all of the agency's employees and officers. The third record that every agency is required to create, maintain, and make available is a reasonably detailed subject matter list. For many municipalities, the preferred way of complying with this requirement is to adopt the LGS-1 record retention and disposition schedule established by the New York State Archives. When an individual makes a Freedom of Information Law request, they have an obligation under the statute to reasonably describe the records sought. So what does this mean? It means they have an obligation to provide sufficient detail to allow the agency to identify and locate the records sought. And in determining whether the applicant has reasonably described the records sought, part of that is going to depend on how the agency maintains its files. Can the agency locate and retrieve the record with reasonable effort? Would locating that record involve searching for a needle in the haystack? Part of it's going to depend on whether these records are maintained in paper or electronic records. I'm going to give you all an example based on my own experience. For many, many years, working for the Committee on Open Government, there's a statutory obligation on the part of government agencies to provide the Committee on Open Government with a copy of any appeal, Freedom of Information Law appeal it receives, and a copy of the appeal determination. So for many years, we would receive those by mail. So every day we would get the mail, and we would open up the mail and we'd read through the mail, date stamp it, and unless there was any red flags, essentially they would get date stamped and get placed in a filing cabinet based on the date they were received. We didn't log them. They were not filed based on the agency that issued the appeal determination. They were just filed based on the date they were received. And so if someone made a Freedom of Information Law request, for example, for an appeal determination issued by, for example, the Department of State, we would have had a very difficult time complying with that Freedom of Information Law request, because we receive between 4,000 and 5,000 appeals and appeal determinations every year. So and we have a record retention policy of 3 years. So that's between 12 and 15,000 appeals that we would have had to dig through because we didn't log them based on agency. So if someone wanted something, an appeal determination for the Department of State, we would have had to dig through between 12 and 15,000 appeals to find the ones that had been issued by the Department of State. And based on very old case law, Court of Appeals case law, we were not required to do that. Now, for the past, say, 5 years, we've started the process of logging the appeals as they come in. And in addition, many more agencies have started sending things to us via email, and it's a lot easier to search things by email. Like, for example, I can go in and type Department of State in our electronic files and pull up a file that says Department of State. But in addition, we have an Excel file, and Candace, our administrative assistant, types in the agency in the Excel file that issued the appeal determination. So we know which filing cabinet, we know which drawer to look in to pull those documents. We know where to look for them now, whereas before we had no idea where to look. So that's an example of the distinction between how we maintain our files, helping us knowing where to look, and whether the person who has made the FOIL request has provided us with sufficient detail to allow us to identify the records sought. With that original FOIL request, just providing the agency wasn't enough. But on the other hand, if they had said, we're looking for a FOIL appeal issued in a particular month within a particular year, that would have made things a lot easier for us. Time limits. There's a lot of time limits that come into play under the Freedom of Information Law. The first one is 5 business days. When an agency receives a Freedom of Information Law request, the first time limit that they need to pay attention to is 5 business days. Within those 5 business days, they need to either provide access to the record sought, they need to deny the record sought, they need to tell the person who made the request that they do not possess the record sought, or if it's a more voluminous request, more complicated request, or if they're an agency that deals with the larger number of FOIL requests, whatever the case may be, they're going to acknowledge the request and state they need more time. When they send that acknowledgement letter stating they need more time, they, in general, the amount of time that they're going to state they need shouldn't be more than 20 business days. However, the statute allows them more than 20 business days if the circumstances attending the request dictates it. If the agency needs more than 20 business days, they need to state in writing why they need more than 20 business days, and they need to provide a date certain by which they plan to respond. My 4th bullet point here is a little, I guess I'm going to say it's a gray area under the statute. The Committee on Open Government has long advised, and we feel that the language of the statute supports this, that the legislative intent was that there was no intent for agencies to be able to take repeated extensions under the statute. The law stated that if the agency needs more than 20 business days, they're supposed to provide a date certain by which they plan to respond. If they were allowed to take repeated extensions, it seems as if that's what the legislative would have stated. However, that's not what it stated. However, the courts seem to have not agreed with that interpretation, and the courts have allowed agencies to take repeated extensions, apparently, as long as the courts agree that the delays are reasonable under the circumstances. 30, when a denial of access is issued, the applicant has 30 calendar days to appeal that denial. When an agency receives an appeal, they have 10 business days to respond to the appeal. All agencies must accept requests via email. An agency cannot require a requester to use its form. This includes electronic forms and portals. If your agency uses a portal such as GovQA, that's fine. There's no problem with offering it as an option, but it cannot require that the applicant use that portal. It can require that the request be made in writing. Unless there are personal privacy concerns, an applicant for records should be permitted to remain anonymous. Permissible grounds for denial. There are many, many permissible grounds for denial that are all based on some type of harm that may occur if disclosure, if the agency discloses the record. We won't discuss every single one of the permissible grounds for denial. We'll discuss the ones that come up the most frequently. The first of the grounds for denial is the only one that is in essence mandatory. If a record is exempt from disclosure by state or federal statute, the agency is always going to want to ensure that it is complying with the disclosure rules that are established by that separate state or federal statute. If disclosure is prohibited by that separate state or federal statute, then the agency is going to be prohibited from disclosing the record. Sometimes it's not a straight prohibition on disclosure, but whatever the rules are that are established by that separate state or federal statute, the agency is going to be bound by that statute as opposed to FOIL. And that's always the thing to keep in mind. Essentially, FOIL to some extent gets thrown out the window, and the agency is going to be bound by this statute, by that separate statute. Some examples are attorney-client communications. When an agency employee requests legal advice from an attorney, from one of its a counsel's office, or you've got maybe a town board requesting legal advice from a town attorney, or the town, the vice versa, town attorney is providing legal advice to the town board. Those communications are covered by the attorney-client privilege, which is covered by New York State civil practice law and rules. If a Freedom of Information Law request is made to a school district, a community college, a CUNY or a SUNY, those records are prohibited from being disclosed to anyone other than a parent or guardian pursuant to the federal Family Educational Rights and Privacy Act. I used to be the Records Access Officer for the Office of Mental Health, and sometimes we would get Freedom of Information Law requests for mental health records, for psychiatric records, and clearly those records are not subject to FOIL disclosure. I never even I wasn't even allowed to know whether a particular person had mental health records. I didn't even ask our people if the person had mental health records. I just denied straight off and said those records are not available through the Freedom of Information Law. Even if the person who was making the request was the subject of the records, FOIL was not the appropriate mechanism. Access to those records is governed by New York State mental hygiene law and the federal privacy regulations. Autopsy records is not governed by the Freedom of Information Law. It's governed by New York State county law. County operated E911 records, the recordings and transcripts of 911 calls is governed by county law. Social Security numbers is governed by Public Officers Law, Section 96A. Vital records like marriage and divorce records and birth records are governed by domestic relations law and health and public health law. There's dozens and dozens of different types of records. Tax law governs access to tax records. There's just dozens and dozens of confidentiality provisions contained in New York State and federal statute that need to be complied with when you're thinking about different specific provisions. When you're talking about different types of statutes, and you always want to make sure you're complying with those statutes before you're complying with FOIL. So that's, other than that first provision, the rest of these grounds for denial are permissive, with the caveat that when you're dealing with state agencies are subject to the Personal Privacy Protection Law. The Personal Privacy Protection Law prohibits a state agency from disclosing records which, if disclosed, would constitute an unwarranted invasion of personal privacy. So there's the distinction where, like, if you're a local government, you could choose to withhold a record where disclosure would constitute an unwarranted invasion of personal privacy. Like, for example, let's use the mugshot example. Say you're a local law enforcement agency and someone makes a FOIL request for a copy of someone's mugshot, and you have a choice. You could choose, it's within your discretion, whether you want to disclose a copy of that person's mugshot on the ground. You could choose to withhold on the ground that disclosure would constitute an unwarranted invasion of personal privacy. Or you could decide to waive that ground and disclose the copy of the mugshot anyway. However, as a New York State level government agency, the New York State troopers have an obligation to comply with the Personal Privacy Protection Law, and they would be prohibited from disclosing a copy of the mugshot unless they need to disclose it for a valid law enforcement purpose. So I just want to distinguish between local government and state agency. State agencies have a higher level of obligation to comply, to not disclose records where disclosure would constitute an unwarranted invasion of personal privacy. This ground for denial is somewhat subjective. What one person might consider an unwarranted invasion of personal privacy, someone else might not consider an unwarranted invasion of personal privacy. But some examples here is if you have a job opening, you have 10 individuals apply for a job opening and only one person is hired. As public employees, we enjoy a lesser degree of privacy than others. So once you are hired as a public employee, a public employee, a lot of information about what qualifies us to do our jobs becomes public information. So information that might be on our resume or our job applications, there's quite a bit of information there that might become public information. However, the identities of the individuals who applied but were not hired could be withheld on the ground that disclosure would constitute an unwarranted invasion of personal privacy. Home telephone numbers, personal cell phone numbers, medical information contained, like, for example, in an employee's personnel file could be withheld. Public employees' home addresses could be withheld. Lists of names and addresses of natural persons, if that information would be used for solicitation or fundraising purposes, could be withheld. So those are just some examples of unwarranted invasion of personal privacy. Law enforcement records. This is a two-part test. You have to meet both parts of the test in order for an agency to withhold records on the ground that records can be withheld for both. It's a law enforcement, and it has to cause some type of harm if disclosed. So first, the record would be compiled for law enforcement purpose. What does it mean to have been compiled for law enforcement purpose? You have to look at what the record is being used for at the time the FOIL request is made, not what the record was originally created for. You're looking at what the record is being used for at the time the FOIL request is being made. So this came about during a case involving a former employee of the governor's office. It involved time and attendance records, which you would not think of as law enforcement records. But at the time the FOIL request was made, these time and attendance records had been gathered and handed over to the United States Department of Justice for a law enforcement investigation. The New York Times made a FOIL request for them, and the governor's office said, no, these have been compiled for a law enforcement purpose. The New York Times says, that's crazy. These are time and attendance records. They're not law enforcement records. It went to the courts, and the courts agreed with the governor's office, with the executive chamber, and said, no, at the time you made the FOIL request, they had been compiled for a law enforcement purpose. The exemption doesn't apply just for criminal law enforcement investigation. It could also be a civil law enforcement function. So there was some litigation that involved the New York State Department of Education, and they were performing a civil law enforcement function. And the courts agreed that the New York State Education Department's civil law enforcement function involved records that were compiled for a civil law enforcement function, and that worked as well. All right, so that was the first part of the test. The second part of this test was that disclosure would cause one of the harms envisioned by the statute. Would it interfere with a law enforcement investigation or judicial proceeding? If the agency who holds the record is not the agency that is conducting the investigation, the agency that holds the record has to reach out to the agency that is conducting the investigation to determine whether disclosure would cause harm. The second possible harm is whether disclosure would deprive a person of a right to a fair trial or impartial adjudication. Would disclosure identify a confidential source or disclose a confidential information relating to a criminal investigation? Or would disclosure reveal a non-routine criminal investigative technique or procedure? And here this has to do with, would it disclose information that would allow a potential lawbreaker to evade law enforcement detection? Would it, sort of maybe perhaps reveal the combination to the safe or something along those lines? Intra-agency and interagency material. So intra-agency means all within a single agency. Interagency means between or among multiple government agencies. And the goal of this exemption is to protect the deliberative process. It allows a single government agency or multiple government agencies to discuss a topic, to brainstorm, to talk about ideas without sort of that fear of any stupid idea that they may have getting disclosed to the public. They can share ideas, opinions, recommendations with each other in writing without that getting if someone makes a FOIL request for those documents, those do not need to get disclosed. If someone emails, for example, if a town clerk sends me an email asking me for my advice, that person, maybe the town clerk, has received a Freedom of Information Law request and needs advice about how to handle that Freedom of Information Law request. And I provide advice about how to handle that Freedom of Information Law request. And again, I can just provide advice. I'm not providing direction. I'm not telling her what to do. I can only provide advice. That advice, those questions and advice can be withheld as interagency material. Sharing draft documents where you're coming up with ideas about how to, propose, maybe it's a memo, maybe it's a draft policy. Those are the types of things that can be withheld until you come up with the final policy. What you are required to disclose is statistical or factual information. So if someone makes a Freedom of Information Law request for a draft document, the portions of the document that reflect opinions and recommendations can be withheld. But if the document contains statistical or factual information, those portions of the document, even if it's still in draft form, need to be disclosed. Instructions to staff that affect the public needs to be disclosed. Final agency policy or determinations need to be disclosed, and external audits external audits, including audits conducted by the state comptroller and the federal government, need to be disclosed. So those are some examples of the grounds for denial that can be asserted by a government agency. There are two types of certifications that an applicant for records may request. And if they are requested, an agency is required by law to provide them. The first, when an agency indicates that it does not maintain or cannot locate a record, an applicant for the record may seek a certification to that effect. Section 89(3) of the law states in part that upon request, an agency shall certify that it does not have possession of such record or that such record cannot be found after a diligent search. So if someone requests that type of certification, the agency is required to provide that type of certification. This is true even if someone has received some records and they're requesting the agency provide a certification that there are no additional records that are responsive to the request. The other type of certification is when an agency provides a copy of a record, the applicant may request a certification that the copy provided is a correct copy of the original. This is not a certification that the content of the record is accurate. It's just that a certification that the copy is a true copy of the original, that the copy looks exactly like the original that's maintained by the agency. Appeals. There are two situations in the statute that give rise to the right to file an administrative appeal. The first is in the more traditional situation where an agency maintains a record and but it denies it either in whole or in part. And the second is a constructive denial of access, and that's where the agency fails to respond to a request within the time limit set forth in the statute. This could be where a person submits a FOIL request and the agency fails to even acknowledge it. This could be where the agency acknowledges it, but forgets to provide a follow-up or a response within 20 business days. This could be where the agency acknowledges it, but keeps bumping out the time limit repeatedly for month after month after month. This could be where the agency acknowledges it, but states we're going to get back to you in 6 months, even though it's a simple request for a single one-page document. And the agency and the person who's making the request does not believe that that's a reasonable amount of time given the nature of the request. It's just, there are certain things, our regulations include a description, the factors that go into what an agency can consider when determining a reasonable amount of time for responding to a FOIL request. So both the agency can look at those factors and the applicant can look in those factors, and they may end up disagreeing about what is reasonable. So the applicant can challenge the reasonableness of the agency's determination. So then they can go to the appeals officer, and the appeals officer is going to have an obligation to take a second look to see if that amount of time the records access officer said it's going to need to respond to that FOIL request. And they may agree with the records access officer about how long it's going to take to respond to that FOIL request, or they may disagree and say, no, I think we can get this done faster. When denied access to a record or any portion thereof, the applicant has 30 calendar days to appeal. The FOIL appeals officer is the head or governing body of an agency, or the person or persons designated by the head or governing body. FOIL appeals officer cannot be the same person as the records access officer. Within 10 business days, the FOIL appeals officer must either provide the records sought or fully explain the reasons for further denial, or a combination of both. The law does not contemplate a remand back to the records access officer. It's the responsibility of the appeals officer to review the records at the appeal level. And always remember, the agency is required to send a copy of the appeal and the appeal determination to us at the Committee on Open Government. Fees. There are two fee structures under the Freedom of Information Law, and these cannot be combined. It's one or the other. If someone would like paper copies, which is becoming less and less frequent over the years, the agency is permitted to charge 25 cents per photocopy for copies up to 9 by 14 inches. An agency cannot charge for search time, cannot charge for review time, cannot charge for any type of administrative cost. All they're allowed to charge for is 25 cents for photocopy for pages up to 9 by 14 inches. That's it. End of story, done. That is the only fee permitted if the person would like photocopies, done. If the copies are coming in some other form, if they're being requested in some other form other than photocopies, or for photocopies larger than 9 by 14 inches, the law allows the agency to charge the actual cost of reproduction for all other records. This is the cost of preparing a copy of the record. And it is, the law tells you what you're allowed to charge. It's the hourly salary of the lowest paid employee capable of preparing a copy of the record, but only if it takes at least 2 hours. So for example, here, if you are scanning the records instead of photocopying the records, if it takes 10 minutes to scan the records, the agency is not going to be permitted to charge a fee. If it takes 2 hours to scan the records, that's when you get to start charging a fee. If it takes person's getting paid $15 an hour, you get to charge $30 for the scanning of the records. If you need to put them on an electronic storage device because the records are too large to send via email, you can charge whatever the electronic storage device costs your agency, whether it's a zip drive or a CD, whatever it costs your agency, you can pass that cost along to the applicant. If you need to have something sent out to a third-party vendor, whatever the third-party vendor charges you, you can pass that cost along to the applicant. But again, your agency cannot charge for search or review time, can't charge for administrative costs. If you are sending it to your attorney to have them review it, that's not a reimbursable cost. The only thing you are allowed to charge for under the law is the time it takes or the cost involved in actually making the copy. This is something that I hope that I can get more and more people to understand. By the time I retire, I've probably got about 10 more years to do it. So I'm hoping, fingers crossed, that I can get through to some more people about understanding, because still all the time people are consistently trying to, agencies still are always trying to charge for administrative costs and the time it takes to review records and redact records, and that's just not a reimbursable cost. The Committee on Open Government does not have enforcement authority. Enforcement of the statute is through a Civil Practice Law and Rules Article 78 proceeding. A successful petitioner can be awarded attorney's fees and other reasonable litigation costs. Those fees can be awarded and are mandatory on the part of the judge when the requester has substantially prevailed and the court finds that the agency had no reasonable basis for denying access. They're discretionary on the part of the judge when the requester had substantially prevailed and the agency failed to respond to a request or appeal within the statutory time frame. As a reminder, anyone is welcome to contact our office by phone or by email with questions, whether you're a government employee, members of the public, media representatives. That's our telephone number, that's our email address, that's all available on our website on our Contact Us page. I am going to go over to the chat feature now. So I'm going to stop sharing my screen. I'm going to open up my video and then switch over to the chat feature. Just a second. Chat. Chat. Make you bigger. I want you nice and big. Come on. Sorry, I'm trying to make it nice and big. It's my old lady eyes can see it. All right, I'm going to start. And then people are free to type in questions as I'm answering questions too. First question I see after we started: if a requester is provided an answer to their request and they don't agree with the result, is the appeal process the same as it would be for a denial? Not really sure I understand this question. Because under the Freedom of Information Law, you're not providing answers, you're providing records. So if the person doesn't believe that they've been provided with all of the records that are responsive to their request, part of it is they could just follow up with you and maybe request clarification. I mean, part of it, sometimes it's a little bit of a back and forth. You know, are we sure? Are we on the same page? Do we, understand what I'm looking for? Part of it could be that they need to request a certification. I request a certification that I have been provided all records that are responsive to my request. And then you would be obligated to provide that certification. Other than that, I'm not sure that, maybe if I'm misunderstanding the question, Jen C can follow up with me down at the bottom, and I'll try to follow up with that. But otherwise, I guess I'm just not quite sure what the question is, because you're not really answering their questions. You're just providing a record, and a record is what it is. So someone then is asking me to clarify that requesters can remain anonymous. Requesters can remain anonymous unless the subject of their records involve personal privacy concerns. So let's give an example. If someone is making a Freedom of Information Law request for a contract, something that involves absolutely no personal privacy concerns whatsoever, then yes, they can remain anonymous. On the other hand, if someone is making a Freedom of Information Law request for a domestic incident report and they would like it unredacted, well then, and they're maybe asserting that they're one of the parties, I don't know how they can't remain anonymous if they're asserting that they're one of the parties, but let's just say they're saying, I would like an unredacted copy of a domestic incident report, but I want to remain anonymous. Well, no, the answer is going to be no, you can't have an unredacted copy of a domestic incident report, or we're going to deny access to an unredacted copy of a domestic incident report if you would wish to remain anonymous. On the other hand, if you are a party to the domestic incident report and wish to provide proof of your identity, the likelihood is you're going to get much more than you would if you wish to remain anonymous. And there's other situations too, where if you're the subject of the report, you're going to get much more than you would be if you were not the subject of the report. There's certain circumstances. But going back to the beginning, is if you were just requesting a copy of a record that would be publicly available to anyone who asked for it, then yes, you should be permitted to remain anonymous. Someone says, can I repeat that for local government, please, on the disclosure? Honestly, I have no idea what that means. So maybe if someone wants to follow up with me by email on that. If a mugshot, for example, was disclosed for one request, would that mean all similar requests must also be honored? For anything that would fall under unwarranted invasion of privacy, no selective bias. Yes, I think that's a good point. Government agencies should, yes, there should be no selective bias about policies. Like, for example, if your policy is if someone makes a Freedom of Information Law request for mugshots, we always disclose mugshots. Or we only disclose mugshots if there's a valid law enforcement purpose for disclosing mugshots, or we never disclose mugshots. There should just be a consistency for our policy. It shouldn't be, we only disclose mugshots for when we don't like the person, and we withhold them when it's for our friends, and that's, yes, this person who made that comment, Diane, that's a good point. It should be consistent. It shouldn't be based on personal or political bias. Correct. Someone is asking, would footage from municipal cameras fall under this exemption? Unfortunately, because I wasn't doing this as I go along, went along, used by police for investigative purposes. Footage from municipal cameras in general are not municipal security cameras are not generally considered records, law enforcement records, unless they're specifically police cameras. I mean, for example, dash cams, body cameras, those are law enforcement records. But like town hall, city hall, security cameras are not generally considered law enforcement records. They're just security cameras. They're just security records. So those would not generally be considered law enforcement records. There might be personal privacy concerns, but they would not be considered law enforcement records. I mentioned right at the beginning that the slides are available on our website. Someone asked, you're not allowed to charge for redaction time. That is correct. You cannot charge for redaction time no matter how long it takes. What other actions besides scanning will qualify as preparing a copy? Another good example is data extraction. If you need a program person, an IT person to conduct a data extraction, that is something that sometimes takes 2 hours or more to prepare a copy of a record. But there's not a lot. There's not a lot of things that take 2 hours or more to prepare a copy of a record. My email information were in the slides. Someone says, are unpaid members of a public body foilable? Their names? I'm not sure what that means. The names of people who serve on a public body should certainly be, I mean, you can go to a meeting and see who they are, so I don't really know how you could not find out who they are. Maybe I'm not understanding the question. Records are foilable. I guess that's what you need to think of. I mean, the question here is, this question says, are unpaid members of a public body foilable? And to me, you're asking me whether I can foil a person. And you don't foil people. You submit a Freedom of Information Law request to a government agency for records. You don't foil people, you foil agencies for records. The next question is it sufficient for agencies using video conferencing to use their video recordings as minutes? I have an open meetings law training this afternoon for people who would like to be trained on open meetings law. When the local township or village law states that the FOIL appeals officer are the board members, is the head of the agency still a FOIL? The Freedom of Information Law says the head or governing body shall serve as FOIL appeals officer. So here they are stating that this says when the local township or village law says, this is a little confusing, but when the local township or village law states that the FOIL appeals officers are the board members. So they're saying that the board serves as the FOIL appeal board. Yes, because the law states that the head or governing body, so here the governing body apparently is serving as the FOIL appeals officer, which is what the law states is permissible. Okay, so Jen Cole's following up. Example would be they ask for a budget. We say that the budget is 30. Okay, so this is follow-up from earlier. So this is someone where they disagree. They ask for a budget. Jen, if you want to follow up with me directly, I don't understand. This doesn't seem like it's a FOIL issue. This isn't disagreeing with a FOIL request. I'm sorry, I'm just not understanding. So if you want to follow up with me directly, you're welcome to. So, because I'm just having a hard time following. All right. As a recipient of FOIL documents, what are my rights in sharing the information learned or key unredacted documents? Once you receive a document under the Freedom of Information Law, you're free to do with it as you see fit. Has there been any opinion about the release of surveillance video or body cam footage and the ability to redact such video or footage? Yes, we have advisory opinions on our website under the keywords body cam, dash cam, and I think also security and surveillance video. Someone is complaining about our advisory opinions. Sorry, some of the people are like following up on earlier comments, and apologies, but I'm having a hard time connecting back to earlier comments because my memory is just not that good. So are police departments obligated to provide disciplinary records of their officers? I guess in general, the answer is yeah. The police department disciplinary records are records subject to the Freedom of Information Law, but they are records just like any other records where they can assert the permissible grounds for denial if they apply. Someone said that they thought domestic reports are not releasable to anyone except the victim. Domestic incident reports, there's no special rules relating to domestic incident reports. You apply the rules of FOIL to domestic incident reports. Are redacted domestic incident reports releasable to the suspect? The same rules of FOIL apply to domestic incident reports. Are you able to provide unredacted police case reports or body-worn camera? If so, do you have to confirm the identity of the person requesting? We have advisory opinions on our website relating to law enforcement incident reports. We have advisory opinions on our website relating to body-worn cameras. Someone asked, what constitutes a list of names and addresses? Does it need to be an actual literal list? The answer is no. If we know that a commercial entity is trying to solicit business for itself and ask for records which contains names and addresses among other information, can we deny under the list exemption even though it arguably is not a list? If you have records that contains names and addresses of natural individuals, this has to be like real people, not vendors, not businesses. You can require a certification that they will not use that contact information for solicitation or fundraising purposes, that it will not be shared with other people for solicitation or fundraising purposes. If they refuse to provide that solicitation, the names and addresses can be redacted from the document prior to disclosing the remainder of the document. You can't withhold the document in its entirety if it's not just a list, but that information can be redacted from the larger document. Someone's asking me whether mugshots can be disclosed after 75 years. I'm not aware of any 75-year rule. Agency is required to provide record in preferred format, but what if that e-record contains metadata that might come under interagency exemption? I don't know why that is relevant. Can someone request for unredacted information? Who decides what should be redacted? When someone makes a FOIL request, the assumption is that they're asking for unredacted information. The agency is asking, the agency as a whole is deciding collectively. You have to decide as an agency who makes those decisions. I can't tell you who decides what should be redacted. That's a decision that, as an agency, you've got to figure out who's making those decisions. Is there a template for a certification letter that either your agency can't locate the information, or you don't have it, or that you've provided everything your agency has related to their FOIL request if one is requested for either situation? I believe we have one available in our pamphlet entitled Your Right to Know. And if not, the best thing that you can do is just model the language of the statute. If a lawyer does a redaction, can that be charged? I think I mentioned that during the program. No. Can you share the link for the open meetings training this afternoon, please? It's available on our website, right on our homepage. When someone foils the public body for records, so it's not a public body, you're foiling an agency. For example, FOIL will request all records that include the word resolution in it. Do I only filter out the paid staff records? Do we also ask for unpaid members? That's not really an appropriate FOIL request. That doesn't reasonably describe the records sought. You can't making a Freedom of Information law request for all records that include the word resolution in it does not reasonably describe the records sought. What time is the open meetings training? 2 o'clock. My FOIL request goes to the town clerk's office, then it comes to me. Is that the legal way? I should get the FOIL request, or should it come straight to me? That's up to your agency. Is the FOIL appeals officer allowed to request the records officer should produce records that was wrongly not? This seems very specific. You can contact me directly. I work for SUNY General Counsel's office. We have someone requesting to see one of our college that was cut off. President's pay stubs. Can you speak on what can be released or not? We have advisory opinions on our website specifically relating to pay stubs and W-2s. When attorney invoices are released unredacted, can the agency and subsequent FOIL request redact it, claiming an attorney-client privilege? It depends on the specific. If the exact same record has already been disclosed, then the privilege may have already been waived. If the type of record has been disclosed unredacted, but then I guess I don't want to delve too deep into something that I don't know the details on. I think this is just too much for a general conversation. Do we have to, by law, disclose our physical address? We've had individuals come into our office demanding records. If we're talking about public employees, then the answer is yes. All right. If anyone has follow-up questions, someone just typed another question. Can an agency require a non-solicitation affidavit prior to disclosing a person's private email address under the FOIL provision for a list of names and addresses? If we're talking about a natural person, yes, you can. It doesn't have to be just mailing addresses or home addresses. It can also be email addresses for contact information. If there's things that we didn't get to today that you have follow-up questions, I'm happy to answer them directly. You can email me. You can send it. If you send it to that Coug email address, just address it to Kristin, Kristin, in the subject line, and I'd be happy to follow up with you. Thank you for joining me today. And someone just said, can we deny a list of names and addresses if you think the certification is not truthful? Just keep in mind that, providing a certification is, that's a legal document. If they file a false instrument, that's a crime. If you have evidence that that they're using this type of information for solicitation or fundraising purposes, it may just be worthwhile that you just not even bother asking for the certification in the first place, that you just deny based on your knowledge that they use this type of information for solicitation or fundraising purposes. That might be my, but anyway, I'm gonna cut off now and hope you all have a wonderful day. If anyone joins me this afternoon, for open meetings law, I don't know if anyone wants to spend that much time on open government in a day, but thank you if you do. All right, have a good day, everyone. Thank you.